Oh, okay. Population Health Subcommittee will now come to order. Clerk, would you please open the voting board up, please? Okay, Clerk, would you announce there?
Madam Chair Lady, you have 8 members present. You have a quorum.
Thank you very much. At this point, we would like to welcome everyone here, and visitors and all, and I want to ask anyone on the committee if they've got any personal orders. Okay, Representative Cheryl.
Thank you, Chairman. I have a little young man today, Brian, wherever he's at, job shadowing today, from Murfreesboro. Would you welcome him? Thank you.
Do we have anybody else? Okay, well, we'll go ahead and get started with our calendar. We have 10 bills on the calendar for today, and so we'll take as our time and try to get through as many bills as we can. But first of all, we're going to start out, we're going to go a little bit out of order. We want to hear from Chairman Rudder on House Bill 0533. Okay. So, Chairman Rudder, your bill is all ready to go. So if you'll give us a brief description.
Thank you.
The motion. Yeah, we got our motion and we got our second, right? And you got an amendment.
I got an amendment.
Okay, so you want to give us the drafting code?
Yes. It's code 3691.
Okay, we've got a motion and a second on adding that amendment. Okay, your amendment is added. And we'll vote. That's right. All in favor? Aye. Any opposed? Sorry. We're good. I'm trying to hurry and get her out of here. Now, all right, let's go.
Okay. I will explain the amendment first. All this does is clarify that the bill does not mandate coverage or entitlement for fertility treatments or contraceptives. It also amends the word individual to healthcare provider for those who have the right to administer fertility treatments and contraceptives. And I apologize. I have laryngitis and I'm doing my best to get through this. So it'll be hit and miss today. But what this bill does, this bill enacts the Fertility Treatment and Contraceptive Protection Act. It provides that an individual has the right to engage in activities associated with fertility treatments and contraceptives, and that the laws of this state do not prohibit an activity associated with fertility treatment or contraceptives, and that the laws of this state clearly acknowledge the right of an individual to perform and the right of the individual to receive or use fertility treatments and contraceptives. That's what this bill does, and I ask for your support.
Okay, thank you. Thank you, Chairman Rudder. Does anybody on the committee have any questions for Chairman Rudder? Okay. We have a motion on the bill. Okay, call for question. All ready to vote? Okay, Clerk, would you please open up the voting board? Has everyone voted? Okay. Clerk, would you please call the roll? The voting.
Madam Chair Lady, you have 9 ayes, 0 noes.
Okay. Chairman Rutter, your bill will move on to full health. Thank you. Okay. Okay, so now we're going to move back to item 1 by Chairman Faison, House Bill 0754. A motion and second. And I think you've got an amendment. So you want to read the drafting code for us,
Yes,
please?
ma'am.
Okay.
Thank you, Madam Chair. Actually, I'd like to remove 2 amendments and then add one, if that pleases the committee. The first one I'd like to withdraw is 4308, and the second was 5068.
Okay. Okay. All right. So another one that you want to add.
And then the draft amendment, the one we'd like to add in committee, it does write the bill. It's drafting with 5099.
Okay. Motion and second on that? Okay, all in favor of adding 005099 to the bill, say aye. Those opposed? Okay, your amendment's on there. You may proceed with your bill, please.
Thank you, Madam Chair. Committee, it's so good to be with y'all. This bill attempts to help individuals who at times in their life decided that they wanted to transition into another gender. Studies have shown that there are a significant group of individuals who chose to transition and later on in their life decided that they wanted to go back. The road back through detransition is not a very easy road. And so this bill does basically 4 things. I wrote it down so we make sure we get it right on the record. First one, it establishes that a county or municipality can't prohibit minors from accessing mental health therapy to address gender dysphoria. Number 2, it requires gender transition clinics that provide gender transition services to also provide transition services for their patients, detransition services for their patients. Increases transparency and reporting requirements for clinics that provide any transition service to the patient. And finally, as amended, it makes clear that a purchaser of an insurance policy issues renewed or amended in this state on or after the effective date selects a policy that includes coverage for gender transition procedures. And the policy must also include coverage for the detransition procedures. So basically, in a nutshell, what we're doing is we're making sure that mental health and physical health is available to anyone who would choose to go through a detransition process.
Thank you, Chairman Faison. Do we have any questions from anyone on our committee? Okay, Chairman Clemens.
Thank you, Madam Chair. Thank you, Mr. Sponsor. My questions are, you mentioned gender dysphoria. That's the first time I've heard the acknowledgement of gender dysphoria from many people up here. So can you talk about what gender dysphoria is and what that encompasses?
You're recognized, Chairman
Thank
Faison.
you, Madam Chair. So I'm coming to y'all as a person who's not in the medical field, but a person who has sat and spoke with several people. The way it's been explained to me, Chairman Clemens, is there is a belief that you are something other than what you are biologically made. And that there was the terminology that was used for 100 years, dysphoria. And until the last 10, 15 years, it's been changed. But I like to refer to it as that because that's what the people who have been through this, who've come out on the other side and then decided to detransition, they say they were in a state of dysphoria with what reality was of their biological makeup.
Chairman Clemens.
Thank you, Madam Chair. So this would require a gender clinic that uses funds provided by the state. How many gender clinics receive funds from the state for the purpose of gender transition procedures?
Chairman Faison.
Thank you, Madam Chair. Chairman, we're putting in here requirements for acknowledging who you are, kind of come out of the closet, if you will, to report what's going on. I don't know, I guess departments of license and agencies in here, they could tell you how many there are, but this also goes to private insurance and public insurance, not just state.
Thank you, Madam Chair. So my question is, I don't think the state, to the best of my knowledge, provides money, public money, to gender clinics for the purpose of gender transitions. So my question is, did your bill cover all the gender clinics that just receive any state funds for any purpose, or specifically for the purpose of gender transition?
Chairman Faison, you recognized.
This bill is geared to go to support anybody in Tennessee who has been to a clinic and has transitioned. So any clinic, anyone who has used insurance to transition into another gender, this bill would apply to them.
Well, thank you, Madam Chair. So I just want to make sure we get this straight, because this is putting a financial requirement on these clinics to pay for detransition if they receive state funds for gender transition services. So I want to make very clear, are we talking about the clinics who receive public funds specifically for gender transition, or are we targeting all clinics that receive any state funds whatsoever for any purpose?
Chairman Faison.
Thank you, Madam Chair. The intent of this bill is to use the word target to make sure that the clinics who do specifically transition work, this is geared towards them. That is the intent of this bill.
All right, Madam Chair, this is important. So we're requiring them to financial requirement on them on the back end, just in case, as your bill says, they requiring them to provide funding for detransition, as you refer to it in here. So I don't think the state's paying for any gender transition services right now. And so if the state's not paying for any gender transition services, then either no clinic would come under this or need to be worried about this provision in your bill, or every clinic that receives any state funding should be concerned about this. That's what I'm trying to decipher. I'm not trying to, parse out, but that I just want to make sure that the clinics know if they're subject to this or not.
Chairman Faison, you recognized.
Thank you, Madam Chair. So Chairman Clemens, any clinic in the state of Tennessee that works with gender altercation, this bill is for them, whether they're privately or publicly funded.
If you got another question, Chairman Clemens.
I'm going to leave it at that for right now. I may have one to follow up. Thank
Okay.
you.
Dr. Kumar, you're recognized.
Thank you, Madam Chair. Thank you, Chairman Faison, for bringing up a subject that's very important and timely and has been neglected. Just to follow up on what has been previously discussed, if a person undergoes the transitioning process, they reach a point in their life, they say, no, it's not the right thing. It's not working out. And there are many underlying mental health issues that make decisions very difficult. And at that time, the person does not have insurance coverage. Can they go back to the clinic and still receive care?
Chairman Faison, you're recognized.
Thank you, Madam Chair. The way this moves forward, if you used insurance, whether it was public or private insurance, to have a transition surgery, that insurance needs to be available for you to detransition. That's how this bill works.
Well, thank you, because that is planning ahead and preparing a person's future. It's not that the work is done, money is out, now you're on your own. I think you're protecting these people who are going through very difficult times in their life, and I thank you for doing that. We have basically focused on the medical, surgical, and mental health aspects to some extent of this condition. And but the use of the facilities to be proactive and be preventive and provide mental health care to these people in the early phase so they are able to make the right decision for themselves and consider the consequences of their decisions. And I think that is a very, very needed and important thing that you're adding, and I thank you for it. Thank you, Madam Chair.
Thank you. Okay, Representative Travis, you had a question?
Yes, thank you, Madam Chair and Leader. On the insurance, I think Doc answered a lot of my questions right there. You're telling me that if an insurance policy paid to have this done, that we're going to mandate them to pay to have it undone. If that's what you're saying, you're going to put a mandate. This is a mandate policy on insurance companies, right?
Chairman Faison.
Thank you, Madam Chair. Yes, that is correct.
That is a mandate. Okay. But if an insurance policy did not pay for this services, then there's no mandate that's going to be required of insurance companies to undo this, correct?
Chairman Faison.
Yes, that is correct, Representative Travis.
Okay.
Chairman Terry, you're recognized.
All right, thank you, and appreciate you bringing the bill. And this is obviously a difficult situation for patients and providers, and obviously with do no harm being part of our oath, and so where this I think can help providers is if somebody goes to transition and obviously that provider wants to do them no harm, thinks that they're doing them good, but at some point in time they may change, the patient may change their mind and want to detransition and feel like they are harmed in this situation that they're in. And so this helps that provider, I think, if to detransition that patient. We're not going to be able to, depending on that patient and what process they've gone down, you can't undo everything, but you can undo what you potentially can do in that and actually reverse some of the harm that patient may think now that they've gone under. And so to me, I think this is a good step that does help those patients and does help the providers. So thank you.
Who else has a question? Or, well, let me check with, Chairman Clemens.
Thank you, Madam Chair. So I'm trying to get this. Like, there's parts of this that actually sound good. We're acknowledging gender dysphoria exists as it should be defined. We're mandating insurance companies to provide medical care, and we're ensuring that individuals receive mental health care and treatment for gender dysphoria. Is there anything else in this bill that I'm missing?
Chairman Faison, you're recognized.
Would you like to sign on to the bill?
No, I'm trying to figure out what I'm missing here, Faison, because this is, I don't, no, that's it. Thank you, Madam Chair.
Travis, did you have a question? Recognized.
Yes, Madam Chair, I do have one more because I just thought of this one more time because being an insurance guy for 40 years and your business, you've been in for a long time. The mandate just does not sit right with me, but I want to do one more. It's hard to sit here and tell us or tell other people how they're going to run their business. I've always, when I come here in 2012, if we saw one mandate passed out, it was unbelievable. Now we see them pass out all the time. But my question is on the mandate part of it again is if this person has insurance and has this done, and 5 years later, they have switched to another insurance company that does not cover this, that they've never covered it, will that insurance company have to pick up the cost of this procedure? You follow me?
Chairman Faison, you're recognized.
Thank you, Madam Chair. Representative Travis, if you have dropped your insurance, this bill would not apply to that. If 5 years later you decide to change your mind and you no longer have that insurance, it would not be a mandate on that insurance to all of a sudden just pick up and cover you. You would have had to keep your insurance. And Madam Chair, if I'd like to address one more thing that is, am I there?
Yes.
Being on the libertarian side, I'm with you on growth of government and mandating what businesses do. But from day one that the legislature started, we do mandate what businesses do. And we mandate what businesses do for the public's protection. And what we have seen throughout the world, Europe especially, America's finally catching on. You maybe saw the reports that came out over the weekend of the gender dysphoria studies and individuals who participated in hormone therapies and transitioning. Evidence-based science and all the studies have shown over the last 2 years that it actually is not beneficial to them. Overwhelmingly has not been beneficial. And it's been so far that Europe is really they're leading in the world right now and saying, you know what, maybe we shouldn't do this. And so my whole intention is not to be a mandate, but for people who got into this and now they wish, you know what, I messed up when I was younger. Now we have a law that we presented and it's at the Supreme Court right now for children who transitioned. I've had people in my office that were 14, 15 years old who transitioned right here in Tennessee. If they still have their insurance and they realize I've messed up, which they have, they've told me they feel like they messed up, the option ought to be there that they ought not to have to pay out of pocket if they still have the same insurance they had when they got it.
Well, Mr. Leader, I appreciate your concern on the mandates and you're for the public, which I am for the public also. The mandates that we have passed out sometimes does have consequences. And the consequences is that if you look at how much you're paying for health insurance today, opposed to what you were paying insurance for 10 years ago, you'll see that. That's just not you. That's just not me, but it's everybody out here in this audience. The premium of health insurance is skyrocketing because we're making these companies pay for something that was never intended, just like car insurance. You know, you start mandating stuff like that. It's just, to me, it's wrong. And we have different opinions about that, but that's the way I believe. But thank you.
Do we have any more questions? Okay, Chairman Clemens.
Thank you, Madam Chair. I appreciate it. So my question is this information that's got to be provided and the data that has to be collected by the department, what's your intent for the use of that data?
Chairman Faison.
We collect as a state, we collect data on all sorts of things. And I think it's incumbent on us as a legislature to somewhat follow this. If we're honest with each other, the last 10, 15 years, this has become in vogue. There are things in society that become popular in vogue, and then they go away and they come back and they go away. I think it's important on us when something impacts our people as much as transition surgeries have impacted our people. It's important that we kind of know what's going on and see the numbers and see the trends. I think it's incumbent on us just to follow what's going on. And I think we're going to get years down the road and realize that this was a blip in human history, and there's better ways to take care of this than massive transition surgeries.
Okay.
Thank you,
Chairman
Madam
Clemens.
Chair. Yeah, so I think certainly been politicized in the last 15 years. I don't to argue that transgender community just began to exist or grow in the last 15 years is pretty interesting. I think it's false. I mean, just you can look back at history and know that that's wrong. But I appreciate your position on that. I disagree with it. I am concerned about the privacy of the data being collected. And what the department intends to do with this, or what the body intends to do with this. I mean, I would hope that it would disprove your earlier statement that a significant number of people want to detransition. I don't know that. I'm sure there are instances where people have wanted to detransition. I don't know that it would qualify as significant. But maybe the data will answer that question. I don't like the idea of collecting data on individuals for that purpose. And I take issue with the fact that that this is in vogue. These are people. These are Tennesseans. They did not just begin to exist or come about as some sort of fashion style. So I appreciate you answering my questions. And Madam Chair, I appreciate you allowing me to ask my questions. Thank you.
Thank you. Are there any other questions on the committee? Okay, seeing we have no more questions for our sponsors. Sponsor, are you ready to vote? Okay, Madam Clerk, will you please open the vote? Okay, Madam Clerk, does anybody wish to change their vote? Okay, Madam Clerk, would you please close the vote? And
Madam Chair Lady, you have 6 ayes, 3 noes, 1 present not voting.
okay. Thank you,
Thank you,
Chairman Faison, and your bill. We'll move on to full health. Okay. Yeah. Next, we are going to bring up Chairman Williams, House Bill 0945. Do we have a motion and a second? Second? We have a second? Have a motion? Do we have a second? Okay, we've got a second. Okay. Chairman Williams, I see that you have an amendment. Okay. Would
Yes,
you
Chair
like?
Lady. Drafting code 004839.
Okay. All in favor of adding this amendment? Okay. Got a motion second? Okay. Okay. Amendment 004839. I thought they voted.
No, they just motioned.
Oh, you just, oh, I thought y'all said. Okay. All in favor of adding his amendment 004839, say aye. All opposed? Okay. Your amendment 004839 has been added, and it's all in proper motion, so you may begin.
Thank you, Chair Lady members. This bill is something that I have been working on with legal and stakeholders for the last several months. It has been a difficult and challenging journey trying to find information regarding what minimum standards are, what the regulations are, what the federal statute requires as it relates to the practice of ART, which is assisted reproductive technologies. That ART, we would better understand ART to be what we know now today is IVF. Today, with the chair lady's guidance and with the members' participation, it's my hope to have a discussion regarding this amendment, and I will describe what the amendment does shortly, with the idea that I can possibly come back with a revised amendment that better reflects not just my own view, but that of this subcommittee and the stakeholders who I've met today, some of which may testify, and some additional stakeholders that I have met along the way. In essence, what this bill does, I think a little back history, as the members may know, in Alabama, there was a lawsuit which occurred regarding embryonic storage, and the byproduct of that court case and the consequential laws that were changed, in effect, made it very difficult, if not impossible, to practice IVF in the state of Alabama. And it was because of those lawsuits. The members may also know that the Attorney General is trying an open case now regarding a fertility clinic that closed abruptly in Nashville. And the reason for that concerns me a little bit. I think I would say, first of all, that there is no desire in my heart or this legislation to prohibit IVF. IVF started in the late 70s as a practice where mothers had an opportunity to have children using this miraculous technology. My concern is that if without state guidance and licensure, that's what might happen in Tennessee, in Alabama, may in fact happen in Tennessee, where the courts decide and interpret the statutes based upon the courts and not based upon their legislative bodies. This bill seeks to do three things. It seeks to set up a licensure for IVF as a practice in Tennessee, similarly to how we do our physician boards now for Board of Licensing, with the idea that if there were a problem with the practice of IVF in a physician, the Department of Health would have the same process associated with inquiry into that practice as you would any other licensed physician. The goal here is not to make it more costly. It's my understanding it would not make it more costly, but that licensure, which may lead to only a certificate at a later date, is, I think, extremely important. That licensure would be based upon the minimum standard that is set by the CDC's minimum guidelines as it relates to the practice of IVF, and to ensure that our state statute includes that minimum guidelines of practice, which most, if not all, IVF practitioners are abiding by today. The second thing that it does is it creates a licensure for cryogenic storage or laboratory storage for embryos. The lawsuit in Alabama was because a cryogenic storage facility had an issue and there were embryos that were lost. And therefore, the courts opined not only about storage there, but also about the value of life as it relates to those embryos that were frozen. So the licensure for the laboratory would be inspected by our own Department of Health, and the Commissioner of Health would have the ability to intervene in the event that that laboratory storage facility did not meet the minimum standards set forth by the CDC in their guidance. The reason for this is in the case that is still open with the Attorney General's office, the Attorney General had to intervene in order to take over the lab because there wasn't enough resources there to keep the embryos frozen. So our Attorney General had to intervene to preserve those when that IVF clinic closed. I don't really want to get into the specifics of that case because it's still open, but I think it's important to know that there is a court case out there that's in the Attorney General's office. Third and finally, what the amendment seeks to do is to opine on what might be a model agreement between a practitioner and prospective parents as it relates to IVF. This amendment does set three guidelines as far as the storage of those or the practice based upon that model agreement of what it would be. In complete transparency, these were included in the language to stimulate a discussion from the members because in spite of my 15 years of being a legislator in this body, I don't think I have the ability to make this decision solely on my own as it relates to the drafting of this amendment. And so the hope would be that we could communicate that. In the language of the bill currently, it does prohibit in that model agreement that the Attorney General, the Department of Health, and practitioners would do when they promulgate rules. In that amendment, it currently states that there would be a prohibition on genetic testing. I'm here to tell you that the prohibition standard was just for a purpose of discussion. There are certain fetal abnormalities that I believe that are important as it relates to preserving and maintaining frozen embryos or those embryos that are produced by IVF, some of which I've shared with you individually about those abnormalities over the weekend and in the previous weeks. Those abnormalities, I think, should be tested for. But there are also things that I don't think that, from my personal view, that we should test for. The vast majority of IVF prospective parents don't have a preference of whether or not their prospective child is a male or a female or has blue eyes or blonde hair or brown eyes. But I think we should determine whether or not most people don't have the means to do that, because it's a very desperate and difficult process. But I do think it's important for us to opine on whether or not that should be the case as it relates to Tennessee statute. And so with that, Chair Lady, one other discussion was, in my discussion with IVF practitioners, those that are in the space, it's my understanding about 80% of parents who utilize IVF to grow their families, about 80% of those folks end their IVF journey with no embryos, zero. Another 20% may end their IVF journey with frozen embryos still in storage. There's a language in the bill that says that discusses the number of embryos that one person can have at any one time. The idea behind that is, if per se my wife and I determined that we wanted to enter the world of IVF and have children, at the intake we would say, we think we want, if we were to say we think we want 2 children, then the model agreement opines that at no one time could I have, my wife and I have 8 embryos frozen in storage at a time. The language says embryos, but the intent was frozen embryos in time. So if she and I implanted 2 and were unfortunate and not successful to carry to term, or we implanted a second time and 2 of those embryos were utilized and not able to be carried for term, then we could go back and have more eggs harvested, fertilized, tested, and then frozen, so that we never had more than 4 times what our intake number said. As I said previously, my concern with the practice of IVF is not to make it more expensive. It's not to make it less accessible. It's to create a licensure and a laboratory guidance to ensure that it is a protected option for Tennesseans going forward, with the idea that we could better determine on behalf of its citizens what that model agreement might look like. And Chair Lady, I appreciate your indulgence. I know that was longer than 5 minutes, but I'm happy to answer any questions the members may have.
Thank you, Chairman Williams. Do we have any questions on the committee for Chairman Williams? Clemens, you're recognized.
Yeah, I was unclear. You had mentioned you were going to revisit this. I was curious about your intentions with the legislation, because I don't want to ask questions about something that's going to be amended.
Chairman Williams.
Thank you. Yes, Chairman Clemens, the desire really is to present the amendment as it is before the body today, with the idea that through further, for instance, I met with a physician 45 minutes ago, and he was able to share with me some new information that he has access to regarding model agreements that the amendment currently does, that already exist through his access to the minimum standards of the CDC. So the idea of whether a model agreement would be necessary, I yet don't know. So the idea would be, we could have a discussion much like we would around a dining room table about the bill, and with the idea that I would roll it a week and work on some additional mandatory language.
Thank you, Madam Chair. I think I'll hold off
you
for
done?
now.
Okay.
Did we have to?
Okay. Yes, we are going to go out. I just wanted to see if anybody had a question before we went out of session. So, okay, we will go out of session. We've got a Dr. George Hill. Is he here today? Okay.
They're not here.
Okay. Okay, we're going to go out of session. Hello, Dr. George Hill.
How are you?
Yeah, I'm doing great. How are you?
Great.
If you'll just state your name and who you're with.
I'm Dr. George Hill with TMA.
Okay. And we're going to give you 3 minutes, so go ahead and
Better
proceed.
get going, huh? Okay. Thank you, Madam Chair and members of the committee for letting me speak. I'll try to get through my comments as quickly as I can so we can have time for questions. And I'm commenting on the bill that I received yesterday. As I mentioned, I'm George Hill. I'm a board certified reproductive endocrinology and infertility subspecialist and founder of Nashville Fertility Center. My desire is that all fertility clinics, not only in Tennessee, but across the country, provide excellent, cost-effective, and evidence-based care to all our patients who need this service. I'm also more than willing to work with you guys to make sure this happens. I want to point out some concerns that I have and some of the requirements that as written are impossible to comply with. The first section talks about this certificate, and I'm trying to understand that, whether this is certification for providers of assisted reproductive technologies. There's not a current certification in that. Doesn't mean we're not certified to provide this service. We are. We're currently certified by the American Board of OBGYN, which is part of the American Board of Medical Specialties. And as I mentioned, I'm board certified in both obstetrics and gynecology and reproductive endocrinology and infertility. So I'm not sure what the additional requirements for this certificate would require and what it would add in terms of expertise. In addition, our embryology lab is inspected and accredited by the College of American Pathologists, and our andrology and endocrinology labs are inspected by the state of Tennessee, and we're also subject to unannounced FDA inspections. My next concern is with this model contractual agreement, which sounds to me like a consent form. As mentioned, SART, which is the Society for Assisted Reproductive Technology, has developed model consent forms, and I'm certainly going to provide those to Representative Williams. The model contract in this bill contains items that are already included in that informed consent. It particularly includes a discussion of risk and benefits. It includes decisions about what to do with embryos for various scenarios like death of the one of the partners or divorce, things like that. So that part of the model contract is already being addressed. The other 2 points of that model contract as written would be extremely detrimental to the practice of reproductive endocrine and infertility in our state and wouldn't provide the most advanced care for our patients. There was a mention about the prohibition on genetic testing that was mentioned. If our patients didn't have access to that, I don't think we'd be practicing according to the current standard of care in our field. And he said that that was not the goal, and I want to work with him to make sure that that's not what happens. But this would, as written, preclude patients who carry genetic mutations that cause severe diseases that lead to early death of a fetus wouldn't be allowed to use that genetic testing to try to have a healthy baby. The other advantage to genetic testing is that if we know with relative certainty of about 98 to 99% that an embryo is chromosomally normal, we can transfer one embryo rather than 3 or 4 embryos, knowing that we still have high confidence of having success in reducing the incidence of multiple births, which is one of the more common complications that we used to have to deal with. And multiple births are always a more complicated pregnancy for both the mother and the fetus, and it adds
Dr.
additional
Hill,
costs to the healthcare
your
system.
time
Am I
is
getting
up.
close?
Yeah.
Okay.
it's
Let
up.
me just mention real quickly, we also are reporting all of our outcomes already to the CDC based on Fertility Clinic Success Rate and Certification Act of 92. All that data is available to all of you, any patients. It also says on there whether our labs are accredited. So let me just stop at that point because I do want to answer any questions that you have.
Yes. Okay. Does anyone have any questions for? Okay. Okay. Dr. Kumar, you go first.
Thank you. Thank you, Dr. Hill. Thank you for coming. Kindly go ahead and tell us the part that you were trying to finish off.
Okay. The part that I was going to finish out relates to the reporting outcomes. The Fertility Clinic Success Rate and Certification Act of 1992 required that we report all our outcomes data to the CDC. We do this through SART. So in 2021, there were 453 out of 501 ART clinics in the country that reported that data. So over 90% of the clinics in the country reported. In 2022, that was 457 clinics. It was like 435,000 cycles on 251,000 patients. And CDC estimates that they gather data on about 98% of all IVF cycles in the country. So that data is easily accessible online. That data, we have to put the patient in within 3 days of when they start their IVF cycle. We have to report all the data on the patient. It's demographic data. It's all the outcomes data, all the way to their pregnancy outcome. If they're pregnant, we have to follow them for 9 months until they deliver. So we have birth outcomes because they're reporting live births. So this requirement for reporting on January the 1st, your success for the previous year, we can't comply with that because we're looking for live births, and that's what you really need to be looking for when you're looking at outcomes data. But again, any of you in this room, and patients use this all the time, they'll go online to that CDC data. You can look up individual clinics. They look at our clinic all the time. It says whether your clinic is CAP accredited, your embryology lab, says what services you provide, all that. So that is already there. We're already reporting that. So my fear with this is I don't want to get into something where we're having to duplicative reporting of things that we're already doing, because that's just going to add cost and burden. In fact, we have one nurse who almost spends her entire time submitting this data for the CDC website.
Chairman Kumar.
Well, thank you for that. So what is the accreditation body for your clinic, for these clinics? How do they get accredited?
For our labs?
Right.
Yeah, the embryology lab is accredited by the College of American Pathologists. You can also do a joint commission, but most people do CAP accreditation, and they come in every 2 years. It's an on-site inspection. I think every year you've got to submit data and things to them, but they come in, they look at all your policies and procedures, they inspect your lab, they look at all your employees, their qualifications, their CME, all those things. So that occurs every 2 years.
So that's for the lab part. What about the clinical practice or medical part?
The physicians.
Is that also accredited?
Our clinic is a member of SART. That's not mandatory, but our physicians are all certified. In fact, all of us are board certified in obstetrics and gynecology. So that was a 4-year residency in testing, and then an additional fellowship, either 2 to 3 years for reproductive endocrine and infertility. So our certification, primary certification, is reproductive endocrine and infertility.
So you go through med school, you get your OBGYN residency, and then you do a fellowship about ART. And once you do a fellowship, is there an exam to take after that so that there is a separate certificate for ART?
Not a separate certification for ART, it's for reproductive endocrine and infertility. So yes, when I finished OBGYN residency, I took an oral exam and then a written exam and then an oral exam. And when I finished fellowship in reproductive endocrine and infertility, I had a written exam and an oral exam. And then I have to maintain certification every year.
That's for basic OBGYN specialist.
That's, OBGYN and reproductive endocrine and infertility, which are the people who do ART.
Okay. Well, thank you, Madam Chair. I might come back.
Okay. Chairman Clemens.
Thank you, Madam Chair. And I'm just going to follow up on this. Seems to require an additional certificate, as you had discussed in the training. And I'm curious, you got med school, residency, fellowship, boards, licensure, and you're, let's say, decorated in many other ways. What other type of information or training can you envision that would be necessary to get a certificate? I mean, what else? How else could you be more qualified?
I don't want this to sound bad, but I don't know of any other way I could be more qualified.
Okay, I'm just,
yeah.
And this bill is going to change. I'm just trying to get my head around the current version.
Yeah,
that
was my point. I feel like everything that we get question about or certified with REI is ART is a part of reproductive endocrine and infertility. It is a subset of what we do. It's not all that we do, because all infertility patients don't need IVF. There's other treatments that you can do that are less invasive, and you certainly want to start with the less invasive, less expensive ways to treat patients. So all patients don't require IVF, but certainly those that do, that's what we do. It is a major part of what we do, but it's not all of what we do.
And so are you familiar with the case in Alabama?
Somewhat, yes.
Okay. To the best of my memory, is the facts of that were a janitor or an employee of a facility accidentally turned off a freezer. Is that right?
My understanding, and again, I'm only commenting on what I heard through the various ways. My understanding was that there was a patient on the psych ward that somehow got into the IVF lab and emptied a straw of embryos out onto the floor. That's my understanding. I don't know that as a fact, but that was my understanding of what happened. And I don't know how they would have gotten into the IVF lab.
Right, and that was a wrongful death case, if I recall. So my question is, this legislation is currently drafted. How would it prevent that type of scenario?
I don't think it would, because how do you prevent someone from doing something as horrible as that is?
Right.
And unfortunately, and the incident that happened in Nashville last April would not have been prevented by this either, unfortunately. And that's a tragic event for those patients that were going through cycles and got stopped in the middle of their cycles. I'm happy to talk with you at any time. Probably not here's the best time about our involvement in that and how we work to try to save those embryos. But that, it hurt all of us that happened.
That's all I have for now, right, Madam Chair?
Chairman Terry.
Thank you. And thank you, Chairman. And thank you for coming and testifying. And obviously this is not my specialty, but I'm always willing to learn, and maybe you can educate me and our committee on this so we can make better decisions. And this goes back to the genetic testing and the grading system. And I guess clarify for me, is the grading systems that you have for the embryos, is the genetic portion part of that, or is that's what I was? Yeah, it's separate.
And let me, if you don't mind, if we've got time, let me just take it back even a step before that, because I did want to address this issue about limiting the number of eggs, which is the way it's written in here. Most people, and I have this conversation with all of my patients, I would have it multiple times a day. Human reproduction is very inefficient to begin with. Most people don't realize that. A perfectly normal couple trying to get pregnant in 1 month has about a 20 or 25% chance of getting pregnant. And that's a perfectly normal couple. So when I talk to a patient about IVF, I give them an example of starting with 20 eggs. And that's a good number of eggs, because the average number we get in an IVF cycle is about 12 to 15. The first step in the process is fertilization. The normal fertilization rate in the human is 60%. That means if you started with 20 eggs, you've now got 12 that fertilized. You lost 8 of your eggs on the very first step. Now, I can't tell you which of those 20 eggs were the ones that weren't going to fertilize. Of those 12 that fertilized, half of those will develop into good embryos that you could have to use. So now we're down to 6 out of that 20. And of those 6, just looking at them by the grading system, which is what we used for years and years, you can't tell if it's chromosomally normal or abnormal. Half of those embryos, on average, are chromosomally abnormal, and that percent goes up the older you are. So limiting patients on the number of eggs that you inseminate really, really hurts you at the bottom end when you're trying to get to that normal embryo that's going to give them the best chance for a successful pregnancy. So out of those 20 eggs, we may only wind up with 2 or 3 normal embryos. And you heard Representative Williams say that the vast majority of patients use all their embryos to try to achieve their family building. And they do because they typically only have 2 or 3 or 4 embryos available at the end of that very inefficient process to get there. Now, in the old days, we used to transfer 3 or 4 or 5 embryos, and even before we could freeze them, we'd have to transfer everything we had. So you all had all sorts of triplets and quads. We've gotten away from that, fortunately, now, because if we have to the best of our knowledge, and no test in medicine is 100%, but the genetic testing on the embryo is about 98 to 99% accurate. If we have a genetically normal embryo, we can transfer 1 embryo and we've got about a 60 or 70% chance of implantation. So we can not only give that patient a better chance of success, we can reduce the incidence of multiple births and all the complications and costs that go along with that. So now, in the old days, when we used to transfer 3, 4, 5 embryos, we rarely transfer more than 1 embryo now. It's almost always a single embryo transfer.
Chairman Terry.
Yeah, thank you. That was much more eloquent than what I was going to say. So, but thank you for that and for educating us, because that is the issue.
Well, one thing I
protecting the
forgot,
women and the unborn. So
yeah,
thank
let
you.
me say one point that that was your real point that I didn't get to there. When you're looking at that grading system, a grade A embryo, which is a perfect looking embryo under the microscope, may be completely chromosomally abnormal.
Yeah. Thank you. Appreciate it. Thank you.
Anyone else got any questions?
Well, thank you for the continued education. I don't know if you'll get CME credits for it. The other question, of course, is the limit on the number of embryos, and you address that. And by implanting only 1 at a time, so you're saying that you will not have spare embryos. Or
No,
would you?
No, we hope to have some spare embryos. In fact, our goal was always that the patient would only have to go through 1 stimulated cycle in egg retrieval, and hopefully you'd have enough embryos to get her 2 or 3 children, whatever they wanted. Now, that wasn't always the case, but that's your goal. So, yeah, you hope to have at least a few embryos left over for a couple of reasons. One is a frozen embryo transfer is not only safer for a patient, it's much less expensive than having to go back through another IVF cycle.
Okay, considering the Alabama Supreme Court ruling that these are persons and the subsequent concern from the public in a major way, and the legislature coming back, and they basically said there is no civil or criminal penalty on how the extra embryos are handled. So in a typical cycle, how many embryos would still be there that are not used, and what is the fate of them? And I think fate of those embryos scientifically is one thing, but on a moral basis, another thing. Kindly elaborate.
Well, typically, as I mentioned, they might have 2 or 3 embryos left over, average maybe 4 if they have more than that. And some do. Although, I recently had a patient who conceived on her 7th transfer. Unfortunately, her other 6 resulted in miscarriages. So fortunately, she had enough embryos to get to her viable baby. But most people don't have that many. Most people do come back and have those embryos transferred. They'll have their first pregnancy, and when that child's a couple of years old, they'll be coming back to have their next embryo transferred and owned. So, and most patients do utilize all their embryos. Of those that don't, some of them will choose to donate, and that was one of the things we tried to encourage patients to do, because we have a lot of patients who would love to have those embryos. And then there's a few that decide to keep them frozen and whatever. So, but our goal is for them to use all their embryos.
Well, the natural concern is what happens to those embryos if they are stored for so long and parents or family loses interest in paying rent for it, for the space. And what happens to them, and what do you think is the society's responsibility in handling those?
Well, I mean, you want to handle the best way possible. I can't make those decisions for those patients. And I know, unfortunately, some of them will decide to discard those embryos. We certainly try to encourage them, if they can, to donate them to other patients who may need them. But fortunately, that's a relatively small percentage of the patients that come through. But yeah, it's a difficult dilemma.
That's a confusing landscape in the sense that in 22, our Attorney General for the state of Tennessee gave a statement to help allay the confusion that disposing an embryo that is frozen is not criminal abortion because it has not been implanted in the body. And definition of abortion is that there is an embryo within the uterus and that's evacuated, and that is abortion. So he did make that statement. Yet we have claims of personhood for these embryos, as well as legal concerns about that these are persons. And we can't really destroy them. Of course, they can be implanted in another person, they can be donated, and people have misgivings about research also, but it's a confusing landscape. On the one hand, we are saying legal institutions are saying that these are persons. On the other, we are saying that if you destroy them, that's not abortion.
Yeah, embryos certainly deserve a special place. But again, based on what you just said, it's
Thank you.
not implanted yet. So
thank you.
Mhm.
Thank you, Madam Chair.
Thank you. Chairman Terry, you have a question?
Yeah, thank you. I need some more CE.
Okay.
So going to that, say you have the top grade embryo and it's frozen, but it's not one that you're going to implant. Would that over time degrade down to a lower level embryo, or eventually what end demise if it's the freezer, or what explain that to me.
Well, the current techniques that are used for freezing embryos, which is a technique called vitrification, which is a very fast freeze. Embryos have very good survival rate from that. Now, they don't always come out the same grade that they went in, but it doesn't appear that that's a huge impact on their implantation potential. So if it was an grade A embryo going in, it may come out as a grade B. Occasionally, embryos don't survive the thawing process, but that's pretty rare. Probably, 90% of embryos survive that freezing and thawing process. But again, the grading, the AB kind of scale that we used to use, it was because that's the only way we had to grade those embryos. You just looked at them under the microscope and you looked at the cells. How many cells were there? Were they symmetrical? Was there fragmentation within the embryo? Those sorts of things to kind of grade it. But I will tell you that there's nothing perfect about that. I've transferred beautiful grade A embryos that didn't implant, and I've transferred grade C embryos that did implant. So as I used to always say, I take my miracles any way I can get them and go with it. So it's a very, for lack of a better way to put it, it's kind of a beauty pageant for embryos, but it's not a very good way to actually grade them. But it was the only thing we had. So it mainly was a system for prioritizing the embryos that you transfer as you would go down the transfer scheme.
Okay. All right. Thank you.
Has anyone else got any more questions while we're out of session for Dr. Hill? Okay, seeing none, everybody ready to go back in session? Okay, we're back in session and I will recognize Chairman Williams.
Thank you. Thank you, Chair Lady, members, for the opportunity to have an elongated discussion in what would be a little more formal setting than we would normally do. I want to thank Dr. Hill for coming to visit me today as well and try to have a discussion about that. I do think it's interesting too, as Dr. Kumar said, there are a lot of different, as a kid, I used to read Choose Your Own Adventure novels because I could get a different ending every time I had. And sometimes in a lot of ways, it feels like that there are many different endings that can occur for people based upon what happens during the process. And so I look forward to working with him and my colleagues to try to better define what we hope to do as far as being able to shore up really the practice of IVF through some kind of licensure or laboratory, even if it means just simply reporting what they're already doing which we don't have access to, and what would happen if a parent failed to pay their storage fees over a certain period of months. Were those embryos considered abandoned and then up for adoption? What happens, in those off cases that's the case? Because there is, as Dr. Kumar said, a lot of discussion about the differences between personhood and viable and non-viable based upon each individual's particular own interest or in case of their worldview. So I look forward to meeting with the members. I'm happy to answer any questions you might have. If you do have something that sticks out to you in the coming days that you would like for me to answer, or Dr. Hill, or as he and I collaborate on consent forms, I'm happy to do that. But thank you, Chair Lady and members.
You're welcome. So without objection, we are going to roll House Bill 04. I said, wait a minute. Oh, what? Okay, sorry.
Chairman Terry.
Chairman. Yeah. Without objection, we are going to roll House Bill 0945 to the Hill on the calendar.
Thank you.
Thank you,
Thank you, Chair
Chairman
Lady.
Williams, and thank you, Dr. Hill, for being here. Okay, well, I need to make an announcement on House Bill 1105 that has been taken off notice. House Bill 1105 has been taken off notice. Okay. All right. So next, we are going to skip over to item number 10 by Chairman Terry, House Bill 990. Do I have a motion? Second? Okay. And you have an amendment on there? Okay. Give us your drafting code.
4937.
Okay. All in favor of adding amendment
Motion
49?
second. Motion.
Did I not get a motion and second on your amendment?
We got it.
Okay. So all in favor of adding 04937 amendment onto House Bill 0990. All in favor, say aye. All opposed? Okay. Ayes have it, and so your amendment is on there, so you can proceed with your bill.
All right. Thank you, Chairman and committee. And this is in effect a clarification bill for the Human Life Protection Act. Section F of the Human Life Protection Act talks about superseding other laws, and thus our clarifying language that we have in other sections of code may not apply. And so when we passed that law, we did not specifically add clarifying language from another part of the code to this section of code to better define or clarify serious risk of substantial and irreversible impairment of a major bodily function. And so the clarifying language in the other part of the code was pre-Dobbs, but since we opened up and are operating under a different set of circumstances, we can adjust that language to better reflect the circumstances that we have today. So what this bill does, it specifies that these certain conditions may cause serious risk of substantial and irreversible impairment of a major bodily function. And so that may include pre-viable, preterm, premature rupture of membranes, inevitable abortion, severe preeclampsia, Muir syndrome associated with fetal hydrops, and an infection that can result in uterine rupture or loss of fertility. The current law does state that you have to provide the best opportunity for the baby to survive. So that doesn't say that these conditions, if these conditions are present, that you can definitely have an abortion. But we recognize that these conditions may lead to substantial and irreversible impairment. And I want to make it clear that these aren't new exceptions, as that the Human Life Protection Act should cover these conditions. However, we want to provide more clarity as we had done previously, and reasonable medical judgment still applies. And my goal is, if we get this through to full committee. As this is our last calendar, my plan is to hold this and to see what the Senate passes.
Okay, all of us have heard Chairman Terry's bill. Has anyone got any questions? Chairman Clemens, you're recognized.
Thank you, Madam Chair. So this is referring to inevitable abortion, serious risk of substantial and irreversible impairment of a major bodily function. If they're not exceptions, then what are you clarifying?
Okay, Chairman Terry.
Thank you. And so it may cause that. So that's what we're saying is, so the issue is if there is an inevitable abortion or something along those lines, that if using reasonable judgment that this causes a risk to that woman, then they could, essentially is clarifying that part for them of that step of having an abortion. Right now, since the Human Life Protection Act doesn't have this clarity in there, which we've had previously in law, that's one thing that they have to think about before they do that step.
And by they, you're referring to the doctor?
Yes.
So the law that we pass and the is incredibly vague in many ways as to what a doctor can and cannot do. It's created a lot of issues with medical care providers being forced to make legal judgments rather than medical judgments. And my concern is you're saying these aren't exceptions, but by better defining what an inevitable abortion is, are you saying a doctor's not going to be held liable, civilly liable or otherwise, or criminally liable if they perform an abortion, if it's inevitable, or if there's a serious risk of substantial and irreversible impairment of a major bodily function?
Chairman Terry.
They would still have to use reasonable medical judgment.
In compliance with these definitions?
Yes.
And are these commonly accepted definitions within the medical profession as far as, so if a medical provider in Tennessee is using their reasonable medical judgment as to what constitutes an inevitable abortion, is it going to contradict this definition in any way, or is this creating more of an issue for them when they're trying to make that determination?
Chairman Terry.
I don't believe that it would create more of a conflict for them.
Madam Chair, do we have anybody who's signed up to talk on this bill?
No, we do not.
Okay, I'm probably going to have more questions in the full committee. Thank you.
Okay. Anyone else on the committee have any questions for our sponsor?
Question on the bill.
Okay. We ready to vote? Okay. Madam Clerk, would you please open the board, please, to vote? Has every member voted? Any member wish to choose or change their vote? Okay, Madam Clerk, will you take the vote, please?
Madam Chair Lady, you have 8 ayes, 0 noes.
Okay. Chairman Terry, House Bill 990 is going to move on to full health.
Thank you, Chairman and Committee.
Welcome. Okay, we're going to go back here to item number 4 by Representative Love, House Bill 0014, and it has been rowed to the hill of the calendar. Okay, next on our list, we have House Bill 0027 by Representative Bain. Is she in here? Okay. Okay, House Bill 0027 has been taken off notice. Well, we're going to pull it back up or what? Chairman Clemens.
Madam Chair, I'd ask that we reconsider our actions on the previous bill. We roll it 2 spots, but the chair beat me to the gavel.
Okay, we'll roll it. A 2-minute recess, so we're going to go out. Okay. Okay, we're going back into session and we can reconsider our actions. Yep. Chairman Clemens, you're recognized.
Thank you, Madam Chair. I make a motion that we reconsider our actions on House Bill 27.
Okay, is everybody ready to vote on reconsidering taking up House Bill 0027? Do I open up the board, clerk?
Yes, we got votes.
Sorry. Okay, clerk, would you please read the vote?
Madam Chair Lady, you have 8 ayes, 0 noes.
Okay, thank you. Okay. Yeah, now we've got to call up the bill. It's House Bill 0027. Okay, Representative Bain, your bill is now ready to proceed.
Thank you. I just want to start by saying thank you so much. It really, really means a lot that you all are allowing me to represent today. I really, really appreciate it, and I won't forget it. So this bill is the Reproductive Freedom Act because Tennesseans deserve the right to make their own healthcare decisions, free from government interference, free from fear, and free from coercion. We are fighting for a Tennessee where every person, no matter their race, class, immigration status, or where they live in the city or country, has the freedom to decide if and when and how they will start a family. This bill fully restores reproductive freedom in our state. It repeals our near total abortion ban, protects healthcare providers from prosecution, and ensures that Tennesseans have access to contraception and pregnancy care, and prevents politicians like us from interfering in deeply personal medical decisions. And I know that some of you will say this bill is too ambitious, but too bold, perhaps, but I've always been called bold, that it will never pass in Tennessee. But for us, this is called what we call in organizing a South Star bill, which means one is that it's emblematic of the vision that we want to articulate and the vision that we want to see in Tennessee in perpetuity. But we're calling it the South Star this year instead of our North Star bill because the South is a region of resistance. It's a region that has resisted oppressive legislation and will continue to do so. So a guiding vision for what we are fighting for. And so the Tennessee that I envision is one where mothers can give birth where and with whom they feel safest. A Tennessee where every parent can raise healthy children in healthy communities with real support and not government imposed fear. A Tennessee where no one is forced to choose between feeding their children and accessing abortion care. And a Tennessee where everyone has the power to prevent pregnancy when they choose and access contraception that works best for them without financial or political barriers. This bill is about more than just abortion. It's about bodily autonomy, economic freedom, and the right to make healthcare decisions without politicians standing in the way. And years from now, when none of us are here, this is the vision that I hope my network and the people here today want to see and hopefully will materialize. I know that for my district, I speak on behalf of my district and Tennesseans who believe in this vision for reproductive freedom, that they want change. And whether this bill moves forward today or not, we're not going anywhere and we'll still be here and we're still going to fight. So thank you so much. And with that, I know we're pressed for time. We're pressed for time, so I'll just ask for a vote and step aside for Representative Johnson.
Thank you, Representative Bain. Does anyone on the committee have any questions? We ready to vote? Okay. Madam Clerk, would you please open the board? Has everyone voted? Anyone wish to change their vote? And Madam Clerk, would you please read the vote?
Madam Chair Lady, you have 2 ayes, 6 nays.
Okay, thank you. The bill, House Bill 0027 fails. And we are out of time, but we are going to continue working on the final calendar at our next meeting next week. So thank you for everyone and for coming today. And do I have a motion for us to adjourn?
Roll all the bills.
No. Yeah. Do I have a motion to adjourn? All right. We're adjourned. Thank you all.